Hello, my name is Maruf Ahmed and this is my ID card. Well, today I'm going to make a presentation on the company law assessment number 1, which is the referral one. And at the very outset of my presentation, I have to tell you about the outline of my presentation. First of all, it's the corporate personality and limited liability. Secondly, the strict compliance of the Salmon and major problems with the group context. Thirdly, recognition of corporate groups. Fourthly, lifting the corporate bail to hold a parent company is responsible. Fifthly, recognition of modern business realities. And finally, Okpabi versus Royal Dutch Shell PLC 2018 modern business realities. So those are the outlines of my presentation, and now I have to talk about the brief discussion about the corporate personality and limited liabilities. So the Court of Lords in Salmon versus Salmon held established the fundamental principles of corporate personality and limited liability, which stipulate that on incorporation, a company becomes a separate legal entity distinct from its shareholders, and that a company is not an agent of its shareholders. So the Court of Appeal in Adam versus Capes held that the Salmon principles also applies in the context of enterprise groups. Disputes the evaluation of enterprise group, it is submitted that the courts in the UK have taken a strict approach in the application of the Salmon principles with the context of enterprise groups. This has been exemplified in the cases such as Adams, where the Court of Appeal held that unless the statute permit, the court would not disregards the corporate bails where the justice required so. Furthermore, the court held that though the law recognizes that the subsidiary companies are creators of their parents' companies under the general law, they are treated as a separate legal entities with all the rights and liabilities. So strict compliance of the Salmon and major problems with the group context. It is submitted that the strict approach to adhere to Salmon has led to two major problems in the group context. First, the application of the separate legal entity status to each entity with a group is arguably inappropriate in the modern business because most commercial activities are highly integrated between the entities in a group. Secondly, the strict approach potentially causes injustice to tort creators of investment subsidiaries, as the UK courts are unwilling to hold a solvent prevent companies' responsibilities for the subsidiaries' debts. Even so, the strict adherence to the Salmon principles in the context of corporate group has been recently endorsed in Pest versus Petrol Resource Limited, where the Supreme Court held that the corporate bail shall only be lifted as a last resort, and that it has to be prevented that a corporate has been used for a relevant wrongdoing. Although this was not the ratio decency of Prest, the Supreme Court principles usually illustrates the potential development towards the strict adherence of the court in lifting of the corporate bail. Fortunately, the cases of Chandler versus Cape and Okpabi versus Royal Dutch Shell PLC seems to have really take a bold and well-defined approach via the conventional route of tort, in which a court may lift the corporate bail so as to hold a parent company is liable for the insolvent subsidiaries' liabilities to tort creators. Recognition of corporate groups. It is submitted that the UK court have failed to recognize corporate group prior to Chandler and Okapavi. An attempt to recognize corporate group with the UK was made by the Court of Appeal in DH and Food Distribution and Tower Hamlets, where Lord Denning MR recognized that since a subsidiary is bound hand and foot to the parent and the subsidiaries are a single economic entity, and the liabilities of the parents and the subsidiaries are attached to the whole group. However, the single economic entity argument was subsequently rejected by the various court. Secondly, Slade LJ in the Adams observed that there is no general principles which stipulated that all the entities within an enterprise groups are to be rejected as a single economic entity. He further noted the Alvazero, where it was held to be fundamental that each entity within an enterprise group is to be treated as a separate legal entity, possessing separate legal rights and liabilities. And thirdly, Robert Golf LJ in Bank of Tokyo versus Caron observed that based on economics, a parent and its subsidiary would be a single entity. However, Robert Golf LJ further stipulated that the UK is concerned with the law and not the economics. However, based on the law, the distinction between a parent and its subsidiary is fundamental and the two cannot be bridged. Lifting the corporate bill to hold a parent company's responsibility. It is submitted that arguably it seems that the Court of Appeal has broadened the scope, as it is the first time that a court is willing to hold a parent companies liable for injuries sustained by its subsidiaries' employees. Moreover, Arden LJ took a flexible approach, as she observed that as long as the parent companies take part in the general operation of the subsidiaries, the parent companies can be liable for the health and safety issues of its subsidiary, and there is no need to prove beyond the fact that the parent companies overshadow its subsidiary feeding operations. In light of what Arden LJ had observed, it is submitted that Chandler arguably broadened the scope in which the court may lift the corporate veil to help the parent company responsibility for its subsidiaries' liability towards creditors, which arguably give an impression that justice have been restored to such tort creditors who are often undercompensated. The Court of Appeal give effect to the modern business realities, as it is recognized that the operation of a parent company and the subsidiary are integrated. It is submitted that the Court of Appeal decided has given effect to the modern business realities, parenting to the fluctuating markets and general economics instability of subsidiaries. Thirdly, it is submitted that the Court of Appeal decided arguably give effect to the modern business realities, as Arden LJ clearly stipulated that one of the reason by Cape PLC had assumed a responsibility for Cape Limited health the safety issues was become a business was in the relevant aspect the same as it is subsidiary. Although Chandler maybe have an important connection with the lifting of the corporate veil via the giving effect of the modern business uh, realities. Arden LJ observed that the Cape PLC trade Cape Limited as a separate legal entities as a Cape Limited uh, maintains the absolute control over its own asset. Arden LJ those concluded by stating that the case is Chandler is not concerned with the lifting of the corporate veil. It is merely concerned with the assumption of responsibility by the parent company in relation to the subsidiaries' trading operations. In the alternative, it was argued that since a court of appeal in the Chandler had recognized that the parent and the subsidiaries' business were the relevant aspect the same, the indicated the potential for future development with regards to the recognition of modern business realities. Hence, it is necessary to examine where the Court of Appeal is Okapobi had indeed given greater recognition to modern business results. Okapobi versus Royal Dutch Shell PLC 2018 Modern Business Realities. It is submitted that the Court of Appeal in Okapobi had not taken the opportunity to recognize modern business realities, although it can be argued that the majority of Okapobi had taken a narrow approach in filing the record the modern business realities of the Shell Group. It is submitted that the approach taken by Simon LJ is more opportunity than that the Sale LJ. First, although it could be argued that the Shell Group framework documents demonstrated that RDS had the laid down details, policies, and practice to manage their subsidiaries and the joint venture. It is submitted that the detailed policies and the practice were not specified tailored for the SPDC. Instead, these policies and practice applied across the all RDS subsidiaries and joint ventures without distinctions. The illustrate the RDS did not have compliant control and the SPDC's operations. Secondly, it is submitted that it would be observed to suggest that RDS, an international parent company, would have intended to the held liable for the operation of all the subsidiaries. As rightly suggested by Sir Geoffrey Boss, it would be surprising if a parent company were to go through the trouble of establishing a network of overseas subsidiaries with their own management structures if it is intended itself to assume responsibility for the operation of each of the subsidiaries. The corporate structure itself tends to militate against the request proximately. Hence, it is submitted that the majority of the Court of Appeal was right in filing the recognition enterprise law, as the recognition of modern business realities would open the floodgates to potential claims by a magnitude of claimants. It may affect the operation of enterprise groups that contribute significantly to country economy. In the conclusion, we can say that hence it can be asserted that the separate legal personality and the limited liability principles are concepts that have contributed to the growth of business and investment capitalism.